The local government areas have expressed an outcry regarding financial autonomy since the states and local government areas have operated a joint account over the years. In the current FAAC allocation system, the federal government receives 52.68%, states receive 26.72%, and local governments receive 20.6%. Even though it was a constitutional matter, the federal government approached the Supreme Court through the Attorney General of the Federation and Minister of Justice, Lateef Fagbemi, to seek interpretation. In the suit marked SC/CV/343/2024, the Justice Minister argued that despite the explicit provisions of the 1999 Constitution, the governors have failed and refused to establish democratically elected local government systems, even where no state of emergency has been declared, to warrant the suspension of democratic institutions in the state. He submitted that all efforts to make the governors comply with the dictates of the 1999 Constitution by establishing democratically elected local government systems have not yielded any result. The AGF argued that FAAC allocations for the local government areas must go directly to their accounts and that the local government areas must be allowed to run independently of their respective states. He added that continuing to disburse funds from the Federation account to governors for non-existing democratically elected local governments undermines the sanctity of the 1999 Constitution. Fagbemi told the Apex Court that the governor's failure to establish a democratically elected local government system is a deliberate subversion of the 1999 Constitution. The AGF then prayed the Supreme Court to hold that FAAC allocations to local governments should go to their accounts and not to joint accounts between state and local government areas, which empower the governors to do as they please with the funds. In their defense, the Attorneys General of the 36 states unanimously maintained that the AGF lacked the legal right to commence the legal action, insisting that the suit be struck out. Some states contended that the AGF suit amounts to an abuse of the court process as they have functional democratically elected local government officials in place. In the lead judgment of the Supreme Court, a 7-man panel presided over by Justice Garba Lawal gave its verdict on the legal dispute over local government autonomy. Justice Emmanuel Agim read the verdict, emphasizing the Supreme Court's unlimited powers to preside over issues between the Federation and the state. He said the Federation suit to protect the country's constitutional structure is within the legal rights of the AGF as the chief law officer of the federal government. The Apex Court then dismissed the defendant's preliminary objection against the AGF's right to file the suit.
The issue of liberty of local government to get their fiscal freedom, that's what the Supreme Court judgment is about, that their money should come direct from the Federation account to the local government and not passing through the offices of the governors. You understand that the governors are very, very bitter and they are not happy. But it's a very, I see it coming because democracy, especially in a place like Africa, like Nigeria, will have to be a work in progress.
Determining the merit of the case, the Supreme Court held that the 1999 Constitution stated that the amount standing to the credit of the 3 tiers of government shall be distributed to each of the arms of government. The Apex Court explained that the 1999 Constitution did not intend any joint account for the 3 tiers of government, but that in the past, the FAAC allocations were sent to joint state local government area accounts for onward transfer of such money to the local government areas, the original owners of the local government area allocations. The court said that procedure was adopted to stop local government councils from coming to the federal capital for their share, and that the local government council should control and manage the funds due to it from the Federation account.
Well, the judgment just delivered by the Supreme Court has finally laid to rest the issue of allocation of funds to the local governments in Nigeria. Their lordships considered the matter and came to a conclusion that although Section 162, so 5 and 6 of the Constitution of the Federal Republic of Nigeria makes provision that money due to local government shall be paid through the joint account. But that provision was considered to be a discretional provision, meaning it can be tinkered with. And in their lordship's judgment, they said that is not mandatory. Or their lordship came to a conclusion that money due to local government shall henceforth be paid directly from the federation account to the 774 local government and 6 municipal council in Abuja. So that laid the matter to rest today.
The allocation goes straight to the chairman. Now, I think to me it's a good thing. But the thing the people should equally, the local government people should do is that there must be monitoring. We should be able to ask them for accountability.
Since I've been here for about 4 years ago, so it's been normal thing for government to allow us to access our money. But for others, I mean, it's a relief to the local government, because if you see Lagos State, it's only Lagos State that the local government is operating. I can tell you now, I'm doing a road of over 1.3 billion, 3 roads. I'm doing it direct, it's not from state.
We've never tampered with local government funds, so it's going to continue. What the local governments have to do is to manage themselves, especially with the upcoming minimum wage, to manage their affairs and make sure salaries are paid. Traditional rulers get the 5%.
From the country, the money they accrued from the allocation, the one that allocation gave to us, so it's what we are using.
On the matter of local government autonomy and the proper running of its affairs, the Supreme Court made a definitive statement. It said governors have no power to determine how affairs are run in local government areas, thereby reinforcing the principle of local government autonomy. After the lead judgment was read, the presiding judge, Garba, stated that the Apex Court had observed and acknowledged the exploitation of the local government areas by successive state governments and was determined to put an end to it.
The judgment on local government autonomy have just been delivered by the Supreme Court. We will get the certified true copy of the judgment as a body. The body of State Attorneys General of the Federation will study it and then we'll come up with our statement on it.
The Apex Court faulted state governments for exploiting the local government areas for decades and ordered the federal government to henceforth pay a 20.6% allocation from the Federation account directly to 774 local government area accounts for the development of the local government areas. The court also barred the state governors or state assemblies from invalidating democratically elected local government councils.
Welcome the ruling of the Supreme Court. Compliance is a given. And our Attorney Generals have applied for the enrollment order, which we'll study carefully. But by and large, governors are happy with the devolution of power in respect to local government autonomy. It relieves the burden on governors. People really don't know how much states expend in building out local governments.
The suit is coming amidst the distribution of 1.143 trillion naira to the 3 tiers of government for May 2024, as announced by the Federation Account Allocation Committee, FAAC. The ruling significantly alters the existing FAAC allocation system.
The Supreme Court can rule, which I think is okay, but in practice, it will take us time to get to where we really want, which is democracy at the local government level. Democracy not spoon-fed by the Godfather. Democracy for you and I. You and I can decide to say, okay, this guy has failed at local government level, let's replace him. Okay. Until we get that, we are still not there.